My name is Mark Pulsifer. After pleading guilty to distributing at least 50 grams of methamphetamine, I was facing a mandatory minimum sentence of 15 years in prison. However, federal sentencing law contains a safety valve provision that allows a sentencing court to disregard the mandatory minimum if the defendant meets 5 criteria. One criterion states, the court shall impose a sentence, without regard to any statutory minimum sentence, if the court finds at sentencing, that 1. The defendant does not have a. more than 4 criminal history points, excluding any criminal history points resulting from a 1-point offense. B. A prior 3-point offense, and C. A prior 2-point violent offense. I believe this means that defendants are only ineligible for relief from the statutory minimum sentence if they have all 3 criminal history criteria, A, B, and C. I have 2 prior 3-point offenses on my record, totaling 6 criminal history points, meaning I meet the criteria of both A and B. However, I do not have a prior 2-point violent offense, meaning I do not meet the criterion of C. Therefore, I am still eligible for safety valve relief because I do not have all 3 criteria required for disqualification.
No, you are misinterpreting the statute. In the government's view, defendants are ineligible for safety valve relief if they have any combination of A, B, or C. Because you have both A and B, you are not eligible for the safety valve.
I disagree.
Don't worry. The Supreme Court is here to interpret the word, and the question we will rule on today is whether a defendant must show that he does not meet any of the criteria listed in the paragraph to qualify for a sentence lower than the statutory minimum. And our answer is yes.
We dissent.
What? How did you make that decision?
We interpret the statute to mean that a defendant is eligible for safety valve relief under this paragraph only if he does not have 4 criminal history points, does not have a prior 3-point offense, and does not have a prior 2-point violent offense.
I dissent. Your reading of the statute ignores 3 important rules of statutory interpretation: ordinary meaning, contextual clues, and lenity. First, ordinary meaning. Unless some feature of a law suggests that a term has a specialized meaning, we must interpret that law as an ordinary reader would. The word "and" indicates that the words it connects should be added together. Therefore, an ordinary reader would understand that a defendant is eligible for relief if he does not have trait A, trait B, together with trait C. This ordinary meaning is affirmed by contextual clues. When Congress uses different words in a statute, we presume it does so to convey different meanings. In other places in this statute, Congress used the word "or," not "and," to indicate that having only one trait in a list is sufficient to disqualify a defendant from relief.
Conjunctions like and or are versatile words that can work differently depending on context, especially because Congress drafts different paragraphs of the same statute at different times. This can naturally lead to variations in conjunction usage and does not prove your point.
Well, the government also wrongly argues that Congress implicitly wanted the reader to distribute the verb phrase "does not have" among each subparagraph of the statute, like this. This theory is so far from the natural meaning of the law that it requires the reader to delete words before the M- and reinsert them in 3 places where they did not originally appear. That is not how statutory interpretation works. If Congress had wanted the reader to distribute the verb phrase, it would have expressly distributed that phrase itself, as it did in 2 other places in the statute.
That doesn't matter. Your interpretation is also incorrect because it creates 2 statutory difficulties. First, it renders subparagraph A superfluous, or without any operative significance. Because if a defendant has a 3-point offense under subparagraph B and a 2-point violent offense under subparagraph C, that defendant will always have more than 4 criminal history points under subparagraph A. The majority's reading eliminates that superfluity because each subparagraph disqualifies defendants from relief even when the others would not. Subparagraph A disqualifies repeat offenders with more than 4 criminal history points, even if they do not have a prior 3-point or 2-point violent offense. Your reading is impermissible because it leaves subparagraph A with no such function.
Contrary to your belief, there are some defendants who have a 3-point offense and a 2-point violent offense, but who do not have more than 4 criminal history points under subparagraph A. For example, when judges are computing a defendant's total criminal history points, they do not count points associated with offenses of a certain age. Therefore, subparagraph A functions to ensure that defendants are still eligible for relief if they have 3-point and 2-point violent offenses that are too old to count toward their total criminal history points.
Well, the second statutory difficulty with your reading is that it allows some more serious offenders to gain relief while excluding less serious offenders. Imagine two defendants. Defendant A has 5 criminal history points from a prior 3-point offense and a prior 2-point violent offense. Defendant B has 15 criminal history points from 5 prior 3-point offenses. Defendant B is clearly a more serious offender, but he would be eligible for relief under Pulsifer's reading, because he does not have all 3 disqualifying criteria, as he has no 2-point violent offense, while Defendant A would be ineligible because he has all 3 disqualifying criteria, even though he is a less serious offender. This is an impermissible reading of the statute.
That is the type of policy argument that this court rejects all the time, and means and, regardless of those types of policy implications. And yet another point works in my favor, the rule of lenity, which requires courts to interpret ambiguous penal laws in favor of liberty, not punishment. Pulsifer's interpretation provides relief from mandatory minimums, and therefore the promise of liberty, for thousands more individuals than the government's interpretation.
But the rule of lenity only applies to ambiguous statutes, and this statute is not genuinely ambiguous. Yes, both of our readings are grammatically permissible. However, your reading is flawed by creating superfluity and being incapable of sorting more serious offenders from less serious ones. Therefore, the 2 possible readings reduce to only one correct one, leaving no role for lenity to play. Accordingly, because Pulsifer has 2 prior 3-point offenses totaling 6 points, he is not eligible for relief. It makes no difference that he is missing a 2-point violent offense.
You rule, Supreme Court.
You suck, Supreme Court.